In this subunit, we're going to discuss a special indefiniteness issue, employment at will. All right, what is employment at will? Employment at will, it's very simple. It's just an employment relationship where the parties have not agreed to a specific duration of the employment. It is the most common employment relationship in the United States. Most U.S. employees are employees at will. All right, let's talk about the law. What does it mean to be an employee at will? Well, first, we remember that employment at will just means that the parties have not agreed to a specific duration. The law is that now you are an at-will employee, which means there is no employment contract. The law does not consider at-will employment to be a contract. Well, what specifically does it mean? Well, the law is pretty easy. It means that the employer can terminate the employee for a good reason, a bad reason, or no reason at all. But it also means that the employee can resign for a good reason, a bad reason, or no reason at all. Under the employment at will doctrine, an employer can terminate an employee, can fire an employee for a good reason, a bad reason, or no reason at all. But there may be exceptions to this doctrine. The first one, and we'll discuss this later, is the employment manual exception. The second, there are various statutory exceptions. There are federal statutes that protect employees, and there are state statutes that protect employees. We will discuss these generally. Finally, there are two common law exceptions. There's the public policy exception and the good faith exception. A word of caution about the common law exceptions. Not all courts subscribe to these exceptions to the at-will doctrine. All right, let's talk about the employment manual exception. Now, the employment manual exception isn't really an exception, but you can see why we need to talk about it here. Right? So some workplaces have employment manuals, and in these employment manuals there are standards of conduct, disciplinary reasons, and disciplinary procedures. An employee can argue, I was reasonable in believing that this employment manual created an employment contract. In other words, you couldn't fire me unless I violated the standard of conduct. You couldn't fire me unless you had a good disciplinary reason. Or you couldn't fire me unless you went through the disciplinary procedures. Right? So once again, the employee is using the objective approach to contract and saying, I reasonably believe the employment manual to be a contract, an employment contract. Well, the employee indeed might be reasonable in believing this, because sometimes the employer will ask the employee to sign the manual. And what they're asking is, sign the manual so that I have proof that you read the manual. But sometimes when you sign something, you assume it's a contract. So maybe the employee is reasonable in believing that the employment manual is a contract. Most employment manuals will have disclaimers that say, this is not a contract. And then the issue becomes, was the disclaimer obvious? When the employee is arguing, I was reasonable in believing that the employment manual was a contract, if the disclaimer was obvious, then employee's argument is less convincing. Let's talk generally about statutory exceptions to the employment at will doctrine. All right, so let's talk first about whistleblower statutes. Many states and the federal government, they have what we call whistleblower statutes, and they encourage employees to report their employer's illegal conduct. Most of those statutes will say that the employer cannot fire an employee for reporting the employer's illegal conduct. In other words, you can fire the employee for no reason, you can fire the employee for a good reason, but you can't fire an employee for a bad reason if that bad reason is that that employee reported you. All right, anti-discrimination statutes, pretty self-explanatory. You can't fire someone because of their race, their religious beliefs, their gender, their age, etc. Anti-sexual harassment statutes, once again, pretty self-explanatory. Workers' compensation statutes, this may not be self-explanatory. State law has an insurance system, usually, where if an employee is injured on the job, they can make a claim and get workers' compensation for their injuries. An employer must be part of this system. The employer cannot fire an employee for making a workers' compensation claim. So you can fire an employee for a good reason, you can fire the employee for no reason, but you can't fire an employee for a bad reason if the bad reason is because the employee made a workers' compensation claim. Finally, federal law protects employees who engage in union organizing. So if you're trying to organize a union in your workplace, the employer cannot fire you. But here's the thing. Union organizing activity seems to be broadly construed. So sometimes, and I've seen this case where an employee sends an email to the other employees criticizing a supervisor, and the supervisor fires the employee. Well, this might be early union organizing activity, right? Complaining about the management might be considered early, nascent union organizing activity, and the law might protect such an employee. There are two common law exceptions to the employment at will doctrine, but be careful, not all courts subscribe to these exceptions. There is the public policy exception, and there is a good faith exception. Essentially, the public policy exception is you cannot fire an employee for a bad reason if it would violate public policy. And the good faith exception, stated succinctly, is you cannot terminate an employee for a bad reason if it would be a breach of good faith and fair dealing. Let's look at these each in turn. All right, first let's look at the public policy exception to the at-will doctrine. Once again, the public policy exception, stated succinctly, is that you cannot terminate an employee for a bad reason if it would violate public policy. This is not universally adopted by the courts. Often, this just looks like common whistleblower protection. In other words, it's a common law doctrine when there is no applicable statute where an employer fires an employee for reporting the employer's illegal conduct. Sometimes an employer will ask an employee to engage in illegal activities and the employee will refuse. And so the employer will fire the employee. Under the common law public policy exception to the at-will doctrine, the employer could not do so. Sometimes an employer will ask an employee to engage in immoral or unethical activities, right? They may not be illegal, but the employee might consider them immoral or unethical. Right? And the employee refuses to do so, and the employer fires the employee because the employee failed to engage in these immoral or unethical activities. Once again, under the public policy exception to the at-will doctrine, the employer could not do so. Now, when we're talking about public policy in this case, please remember that we're not talking about individual conscience, right? So if there is something that you consider distasteful or immoral, and you refuse to do it at work and your employer fires you, you're not necessarily protected by the public policy exception to the at-will doctrine, unless there is a greater consensus in the community that this would be a violation of public policy. So once again, your individual conscience about a matter is not the standard. It is about the community and how the community views this activity. If the community views this activity as immoral, unethical, or a violation of public policy, then the public policy exception to the at-will doctrine might protect you. Let's talk about the good faith exception to the at-will doctrine. This one is even less universally adopted. Only a very few jurisdictions adopt the good faith exception to the at-will doctrine. Please note, however, even in jurisdictions that adopt the good faith exception to the at-will doctrine, the doctrine does not mean that the employer cannot fire you. Right? It does not mean an implicit duration in the employment relationship. What it means generally is that you may not fire an employee merely as a pretense to avoid paying something that you owe to that employee. Once again, under the good faith exception to the at-will doctrine, if a court adopts this exception, it merely means that an employer cannot fire an employee just as a pretense to avoid paying something to the employee that the employee has already earned. Once again, very few jurisdictions adopt this exception to the at-will doctrine.